Welcome to this session on the GDPR. The EU General Data Protection Regulation, or the GDPR, is probably one of the most important changes in data privacy regulation in the last few decades. This regulation fundamentally reshapes the way in which data is handled across every sector from healthcare to banking and beyond. It took about 4 years to prepare this and to debate it, and it was finally approved by the EU Parliament in April of 2016. It was enforced in May of 2018, and organizations that aren't compliant can face heavy fines. The GDPR replaces the Data Protection Directive, and it's designed to do this: harmonize data privacy laws across Europe, protect and empower all EU citizens' data privacy, and reshape the way organizations approach data privacy. The GDPR really changes the way in which sectors manage data, as well as redefines the role for key leaders in businesses who have to ensure that they have watertight consent management processes in place, along with effective data rights management systems to ensure that they don't lose their most valuable asset, data. Now, the aim of the GDPR is to protect all EU citizens from privacy and data breaches in today's data-driven world. Although the key principles of data privacy still hold true to the previous directive, there have been many changes that have been made to the regulatory policies. Arguably, the biggest change to the landscape of data privacy comes with the extended jurisdiction of the GDPR, as it applies to all companies processing personal data of data subjects residing in the EU, regardless of the company's location. Previously, territorial applicability of the directive was ambiguous and referred to data process in context of an establishment. This topic in particular has arisen in a number of high-profile court cases. The GDPR makes its applicability very clear. It applies to the processing of personal data by controllers and processors in the EU, regardless of whether the processing takes place in the EU or not. The GDPR also applies to the processing of personal data of data subjects in the EU by a controller or processor not established in the EU, where the activities relate to these things: offering goods or services to EU citizens, irrespective of whether payment is required, and the monitoring of behavior that takes place within the EU. Non-EU businesses processing the data of EU citizens also have to appoint a representative in the EU. Organizations in breach of the GDPR can be fined up to 4% of annual global turnover, or 20 million euros, whichever is greater. This is the maximum fine that can be imposed for the most serious infringements. For example, not having sufficient customer consent to process data, or violating the core of privacy by design concepts. There's a tiered approach to fines. For example, a company can be fined 2% for not having their records in order, not notifying the supervising authority and data subject about a breach, or not conducting an impact assessment. It's important to note that these rules apply to both controllers and processors, meaning clouds are not exempt from GDPR enforcement. The conditions for consent have also been strengthened, and companies are no longer able to use long, illegible terms and conditions full of legalese. The request for consent must be given in an intelligible and easily accessible form, with the purpose for data processing attached to that consent. Consent must be clear and distinguishable from other matters, and provided in an intelligible and easily accessible form, using clear and plain language. It must be as easy to withdraw consent as it is to give it. Under the GDPR, breach notifications are now mandatory in all member states where a data breach is likely to result in a risk for the rights and freedoms of individuals. This must be done within 72 hours of first having become aware of the breach. Data processors are also required to notify their customers, the controllers, without undue delay after first becoming aware of a data breach. Part of the expanded rights of data subjects outlined by the GDPR is the right for data subjects to obtain information from the data controller as to whether or not personal data concerning them is being processed, where, and for what purpose. Further, the controller should provide a copy of the personal data free of charge in an electronic format if it's requested. This change is a dramatic shift from data transparency and empowerment of data subjects. Also known as data erasure, the right to be forgotten entitles the data subject to have the data controller erase his or her personal data, cease further dissemination of the data, and potentially have third parties halt processing of the data. The conditions for erasure, as outlined in Article 17, include the data no longer being relevant to the original purposes for processing, or a data subject withdrawing consent. It should also be noted that this right requires controllers to compare the subject's rights to the public interest in the availability of the data when considering those requests. The GDPR introduces data portability, the right for a data subject to receive the personal data concerning them, which they have previously provided in a commonly used and machine-readable format, and have the right to transmit that data to another controller. Privacy by design is a concept that has existed for years, but it's only just becoming part of a legal requirement with the GDPR. At its core, privacy by design calls for the inclusion of data protection from the onset of the designing of systems rather than as an addition. More specifically, the controller shall implement appropriate technical and organizational measures in an effective way in order to meet the requirements of this regulation and protect the rights of data subjects. Article 23 calls for controllers to hold and process only the data absolutely necessary for the completion of its duties, also known as data minimization, as well as limiting the access to personal data to those needing to act out the processing. Under the GDPR, it is not necessary to submit notifications or registrations to each local data processing authority of data processing activities, nor is it a requirement to notify or obtain approval for transfers based on model contract clauses. Instead, there are internal record-keeping requirements, and data protection officer appointment is mandatory only for those controllers and processors whose core activities consist of processing operations which require regular and systematic monitoring of data subjects on a large scale, or of special categories of data, or data relating to criminal convictions and offenses. Importantly, the data protection officer must be appointed on the basis of professional qualities and, in particular, expert knowledge on data protection law and practices. The data protection officer may be a staff member or an external service provider. Contact details must be provided to the relevant data processing authority. The data protection officer must be provided with appropriate resources to carry out their tasks and maintain their expert knowledge. The data protection officer must report directly to the highest level of management and must not carry out any other tasks that could result in a conflict of interest. What about data subjects under the age of 16? Parental consent is required to process the personal data of children under the age of 16 for online services. Member states may legislate for a lower age of consent, but this will not be below the age of 13. Data plays a critical part in both digital and direct marketing strategies, and therefore marketers must ensure that they have demonstrated clear compliance and consent. Chief marketing officers and marketers themselves must demonstrate how the data subject has consented to the processing of their personal data. Marketing databases have to be cleansed and reviewed to ensure that the organization can identify consent which has been granted lawfully and fairly. Although the GDPR only affects citizens living in the European Union, it is recommended that companies that operate internationally ensure all of their global audience is GDPR compliant to meet stringent data regulations in the future. So how can people like Chief Information Officers manage consumer trust? Increasingly, CIOs are embedding personal data sharing controls seamlessly into existing and pre-authenticated customer touchpoints. This gives customers the gift of choice, allowing them to change, rectify, and revoke their consent at ease. In short, it unlocks the power of data at the lowest risk to both customers and banks. Chief Information Officers must perform a privacy impact assessment to show how personally identifiable information is collected, used, and shared by an organization. The PIAs allow CIOs to ensure that privacy by design is default in a business. As personally identifiable information can be present across a range of platforms, such as cloud-based applications or internal tools, all data needs to be inventoried. CIOs must demonstrate a risk-based approach to data protection through deletion, encryption, or redaction of data, dependent on its sensitivity. Finally, CIOs must have strategies in place to issue breach notifications to regulators within 72 hours. CIOs that are not compliant are in danger of losing credibility and consumer trust in their organization overnight. In this context, it's unthinkable for a forward-thinking organization not to make every effort to reduce corporate risk and eliminate liability when it comes to both handling data and allowing third-party access to it.